Yes, Your Honor.
Hi, good morning.
Good morning.
All right, you're here, Mr. Howard-Randolph?
No, I didn't hear him. He just called me. I am headed to you all.
Okay.
Yep, I think we're just preparing for trial. I have not received discovery. Frankly, that's the first time I've heard from Mr. Howard-Randolph since he was in jail.
Okay, all right, Counsel, we can address all that when you arrive, okay?
Okay.
Thank you.
Okay. Go!
Hand me my screen box. Now go freak.
Have a good day. This is the matter of the City of Wyandotte versus Nicholas Vitt, 24191.
Ready, Your Honor. Good morning, Your Honor. Neil LeBoy here on behalf of Nicholas Vitt, who stands to my right. Mr. Vitt, would you state your name for the record, please?
Nicholas Vitt.
All right, thank you, and I apologize for your wait today. Today's the date scheduled for sentencing in this matter. And also thank you for dressing appropriately for court. And counsel, as to the report, did you have an opportunity to review the report and it's on your client's plea to public intoxication?
Yes, Your Honor. I should also point out that I'm standing in for the attorney of record, and I do so with the permission of Mr. Vitt. Is that correct?
Yes, sir.
Thank you.
All right,
Yes,
thank
we
you.
have had an opportunity to review it. A couple of corrections, perhaps. There's a charge under the criminal history from October 30, 2021. Client advised that matter was ultimately dismissed. There was no conviction arising from that. Additionally, there is an old matter from Wichita, Kansas, which, again, this may be just semantics. It says diversion completed. His understanding was that matter was dismissed and not result in a conviction. But again, that may mean the same thing. It says diversion completed. He asked me to just point out those two corrections, I suppose. Beyond that, it appears to be accurate in all other respects. Addressing the recommendation, there's two items: fines and costs. Seems quite appropriate under the circumstances. Question regarding why the alcohol tether. Is it necessary? Is there any value in this particular case? First of all, he's not on probation. How do you monitor such a thing? Second point, he does heavy construction work, and having a tether on his ankle would create a hardship, shall we say, in terms of the type of work that he does, construction moves and so forth. And furthermore, the offense involved, I know the court's aware of this, but it was not a driving offense. He specifically knows better than to drive if he's had something to drink. And so hardly a menace to anyone but himself under circumstances. However, certainly was not behavior that he's proud of, and he has accepted responsibility for that behavior.
Okay. All right, well, a couple of things. Number one, I'm sorry, which case was it that you said was dismissed? Not the diversion, not the with Kansas, but the other?
He's explaining to me there, Your Honor, the last one, the Riverview matter,
Yes.
and his understanding that it was some type of a diversion on that case and didn't result in conviction. Can you explain to the court what you're telling me?
I had made a plea arrangement with my attorney at circuit court that it pled down to a misdemeanor, and that if I had completed my probation successfully, it was my understanding that it was going to be off my record. And that was in 2020. It got bound to a year. Actually, Your Honor, you were the one that bound me over for that.
Okay, well, the good news is I know that I did, right, but you're not familiar to me, so that's not a bad thing.
Yes,
So,
ma'am. That was just a technical thing. I just noticed it on, that's why I had mentioned it to him.
let me just see what it says here.
James Schlaff was my attorney.
What's that?
Attorney James Schlaff was my attorney.
Okay, yes, there are 1, 2, 3, 4 charges of assault, resisting, obstructing an officer, malicious destruction of property, actual attempt, pled guilty to attempt, sentence to attempt, probation 2 years. You started April of 22. Okay, discharged from probation. However, what was it under 771.1 status? I can't imagine you were eligible for diversion, so it wouldn't be completely off your record. It may have been.
Maybe it was a misunderstanding between me and my attorney, and maybe I misunderstood him. I mean, everything was being done by Zoom at that point. I never did go to court and appear. I did it, like I said, I did appear here in court to be bound over, but maybe it's my mistake, my misunderstanding.
Right, and it doesn't show me, it doesn't pull up what your probation order was. So, it shows though it was pled down to attempt.
Yeah, misdemeanor, I was told it was pled down to misdemeanor.
Yes, it doesn't show anything on here regarding any under advisement statutes or anything of that.
I'm sorry. Okay, I had an issue with the probation department down there from circuit court. Like I had to go through a couple hoops because I had paid all my fines up front, and they told me that I was eligible for early release on my probation if I had all my fines and costs and all my classes met. And I ended up having to go back a couple times and having them pull records because I in fact did. And I produced the documents that showed that I did pay. So I don't know if it was clerical error or not. It may be just a misrepresentation on my part. I just thought that was the understanding.
Okay, well, it's showing on there as a conviction for the attempt, sir.
Okay.
So in counsel, the other thing I wanted to point out is that, you know, Mr. Vitt not being a menace to anybody, I mean, he was in the middle of the road. He was in the road. He was highly intoxicated and he was in the road. I mean, that's a danger not only to himself, but also to the public. And so, and it appears as though, based upon review of Mr. Vitt's criminal history, that there are a number of matters that have occurred that involve alcohol, sir. That seems to be what happened. I mean, you seem to get in trouble.
Couple, most are decades old. And I was crossing the street, Your Honor. I wasn't just in the middle of it.
Okay, but you fell down. You fell down.
Yes, I tripped and I fell. That is correct. But I was crossing the street and I was walking down Corey over so I could cross over Pennsylvania because I live off of Jefferson in between Pennsylvania and Sibley Road. So.
Well, and I will give you credit for not driving, so that's good.
Yes, I had my keys. I had the ability to drive. I made a conscious decision to walk home.
And so if you're tested today, what's in your system?
I'm a lifelong smoker, as I indicated at the probation assessment. So, I mean, my levels will be low because I haven't smoked since you told me. And that would be it.
Okay. Here's what this court's going to do. I don't find that probation would be appropriate in this matter, but what I am going to do, and I do understand that your client works construction, but I also know that you can still have an alcohol tether while wearing work boots. May not be the most ideal situation, but the court's not going to send it to jail, but I do think that there needs to be some monitoring and accountability. The court's going to order 60 days on the alcohol tether.
Is there any way that we might possibly be able to report for that? Because my boots, literally, I was on a tether for release before, and I can't get my boots around the tether and laced up at the same time. I would be willing to, come in, according to however often you would want me to, and to the probation department and give a breathalyzer, give a pH strip like they used to do, however you want me to do it. It's just that it really wears on my ankles. I went through it with that RO case. And it literally rubbed my ankles raw. I mean, if the court would oblige me, I'd be willing to do whatever would satisfy you just to avoid the tether. It's very cumbersome and it's very painful because I wear calf-high mud boots. So I'm working the grade for an asphalt. So.
Okay, so what I'm going to do is I'm going to leave it to the tether company to determine what would most effectively accomplish monitoring your alcohol consumption and what type of device. Okay. So another one of the options may be SoberLink, the device you blow into 6 times a day.
6 times a day?
Yep, every 4 hours.
Is it mobile?
Yes. Yeah, you can put it in your pocket.
Oh, okay. Okay.
So, so we'll get that information to you. You're gonna stop over probation and somebody will be with you in just a moment. As the
Okay.
fines and costs, the court's gonna order a $300 fine, $100 screening assessment fee, $300 for cost of prosecution, crime victim assessment fee of $50. That's a total of $825. You posted a bond of $250. Do you have any other money to pay today, sir?
What was the total? Yes. I do.
$825.
$825.
So that's $575 is the balance.
I can pay, 200.
Okay, so $450 will be paid today.
No, 200 would be paid today.
Right,
Oh,
I'm fine with the bond also, it's $450.
Oh,
I know math isn't my strong suit, but that one.
No, I misunderstood what you meant, I'm sorry.
Okay. And so how much can you pay on your $375 balance per month, and what day of the month works best?
I could have that balance paid in full if you're ordering 60 days
Okay,
of monitoring,
so I will order by July 12th.
sure.
All right, please have a seat in probation, somebody will be with you shortly, sir.
All righty, thank you, ma'am.
Have a good day.
Thanks.
All right, we are going on the record in the matter of the state of Michigan versus Sherrell Wright, 24547. And detective, your name for the record, please.
Over a little bit here. Thank you. Detective Steve Saber, Your Honor.
All right, please raise your right hand. You solemnly swear or affirm the testimony about to give this matter the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed on the warrant.
Thank you, Your Honor. On 5/3 of 2024 at approximately 8:17 in the afternoon, Officer Kyle Cox, along with his partner, Officer Tyler Grote, were patrolling in the area of Biddle and Emmons in the city of Wyandotte, County of Wayne, in the state of Michigan, in which they observed a blue Chevy pickup truck bearing a Michigan license plate, Edward Mary Sam, traveling northbound on Biddle. A lean check of the vehicle from their police computer of that license plate revealed that the registered owner, Sherrell Wright, was not a valid driver's license. He was not a valid licensed driver, and that also the vehicle had no insurance. The officers effectuated a traffic stop, but not before observing significant furtive gestures and movements from the backseat passenger of the vehicle, who was later identified as defendant Sherrell Wright. Officers made contact with Anthony Wright, the driver, and the front seat passenger, Frank McKinney, in addition to Mr. Sherrell Wright being in the back seat. Officers got consent for a pat down and a search of the occupants and also the vehicle. None of the men had anything illegal or illegal items on their person, but inside the vehicle on the floor where Mr. Sherrell Wright was sitting, Officer Tyler Grote observed in plain view multiple cut-up lottery tickets, which is known in our training and experience as a way to commonly package illegal narcotics. Directly on the rear floorboard under where Mr. Sherrell Wright was sitting in the back seat. Once moved, the cut-up lottery tickets, a cellophane bag containing an off-white chalky substance and a loose off-white chalky rock-like substance was discovered. Officers advised Sherrell that he was under arrest for the possession of narcotics. Upon further search of the vehicle, Officer Kyle Cox located another cellophane bag in the back seat area wrapped up in a cut-up lottery ticket where Mr. Sherrell Wright was seated, and inside that was a brown powdery substance. The officers issued Anthony and Frank tickets for the loitering where drugs were used, sold, or kept, and sent them on their way, in addition to the driver, Anthony Wright, for no insurance. At the station, officers field tested the suspected narcotics, and one tested positive for cocaine, the other tested positive for fentanyl. Mr. Sherrell Wright had $434 in miscellaneous U.S. currency, and the officers completed a forfeiture notice for the forfeiture of assets, of that drug asset forfeiture that Mr. Sherrell Wright signed and got a copy of. Thank you, Your Honor.
All right, thank you. Upon examination of complaining witness, I find the offenses charged or committed, there is probable cause to believe the defendant committed those offenses. And counsel, your appearance, please.
Yes, Your Honor. Good afternoon. Neil Bloy here on behalf of Sherrell Wright, who appears via video conference for custody.
All right, Mr. Wright, your name for the record, please.
Sherelle Wright.
Okay, is there a reason why you can't stand up, sir?
Oh,
Thank you.
Okay. All right, so council, as to the arraignment,
Yes, with respect to the arraignment, the client waives the formal reading and stands mute to the charges.
the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And the court's going to also order, sir, have you listen to the following rights. You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you had the opportunity to speak to an attorney today, correct?
yes,
You also have, and the court's also signed a petition to order for court-appointed attorney for felony matters. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
yes,
All right, the court's gonna schedule this matter for probable cause conference May 16th at 9:45 a.m. And counsel as to bond.
As to bond, my client advises that he is self-employed. He lives home in Detroit with other family members. He advised me that he has never missed a court date. We would ask the court to take those things into consideration when setting a nominal bond.
All right, Mr. Wright, where do you work?
I do landscaping, I help out with my uncle, I do little things like that in the neighborhood. You know,
All right,
paint
if
a
you're to
little,
test today, sir, oh, I'm sorry, what was that?
I do a little painting, I do a little plastering, you know, work like
All
that.
right. All right, if you're to test today, sir, what's in your system?
Nothing,
How long have you lived at your home in Detroit?
for a good while.
I'm sorry?
I've been staying there for a good while, I just moved, I moved with my uncle. I've been working with him.
Okay. All right, and have you always lived in the state of Michigan?
Can you repeat that? I didn't quite hear you.
Have you always lived in the state of Michigan?
Yes, ma'am.
All right, and you're not currently on probation or parole anywhere?
Can you repeat
Are you
that?
on probation? Are you on probation or parole anywhere, sir?
No, no, ma'am.
And are you out on bond in any other jurisdiction?
No, ma'am.
All right, and Detective Sabo, would you like to address bond?
Yes, Your Honor, I think because of the nature of the length of term and punishment, potentially dollar amount wise, it's fairly significant, not only because of the 8-year fentanyl and the 4-year cocaine, but it's a habitual third notice for this habitual offender. So I would recommend a $25,000 cash bond or surety and a tether, and not to have any alcohol or drugs not prescribed to this defendant. No weapons either. Thank you, Your Honor.
All right, thank you. All right, so what the court's going to do is, based upon the criminal history of Mr. Wright, the nature of the charges, the habitual offender status of this matter, the court's going to ensure Mr. Wright appear in court. The court's going to order $15,000, 10% cash surety bond in this matter. In the event you post bond, sir, you're not to possess or consume the alcohol or drugs that are not prescribed. And we'll see you back on May 16th. Thank you.
Thank you.
All right,
Thank you, Judge.
Have a good day. We're on the record matter of the city of Wyandotte for Sean Zajic, 24548, 24546, 23681 ABC, and 231957.
Good afternoon, Your Honor. Neil DeBoy here on behalf of Sean Zajic, who is in custody and appears to be at the teleconference.
Okay, Mr. Zajic, your name, please.
Sean Zajic.
Okay. So you previously failed to appear for sentencing, and that would be on 23681A and 231957. And now you're in custody. And so the court's going to recall the warrants and As to the new matters, council.
Yes, with respect to the new matters, that's 24-246, 24-548. Client waives a formal reading and stands rebuked to those charges.
All right, the court waived the formal reading, enter a plea of not guilty for purposes of the arraignment on both of those matters. We'll schedule these matters for pretrial.
I'm not scheduled May 27th.
I'm sorry, May 15th at 9:15 a.m.
So, just for the record, May 15th?
May 15th.
May 15th.
And ask to bond counsel.
As the bond, Mr. Zajac advises that he is a longtime painter with the union. I believe he told me it's been 16 years. He lives with family, does not support any children at this time. Beyond that, he would like to get back to work. This is obviously going to resolution that's going to involve probably significant fines, costs, etc. And so the court would could consider a personal bond in this matter. We would greatly appreciate it. And we are, I may also say, on the other two matters, these prior matters, and you may have, my thought was, you've already set aside the warrants, schedule these for the same date, wrap this all up in one.
Yes, that's what I'm going to
That's
do.
what I, that's what
Yep.
other than that, nothing further.
Mr. Zajac, where do you live?
39 Trenton, Michigan.
39. Is that a home, sir?
It's a condo.
A condo. And who do you live there with, sir?
My sister.
Okay, well, these matters, we've had some matters pending for a while, sir, for you. You were supposed to have appeared back in October for sentencing on your other matters. And you just kind of blew us off.
One time I was in the hospital.
Okay, what about the other time? And have you been in the hospital consistently since October?
No, I don't really remember the other time.
Okay, you also have 5 other warrants out for your arrest. That was as of October. I don't know what you're at, how many warrants, if any more, you've accrued. And in fact, you had 2 encounters with the police on May 6th. One was for public intox, one was for disorderly conduct. And apparently, you were a concern, a danger to yourself, sir.
I've been working and I've actually been getting my stuff together.
All right, well, here's what I'm going to do, sir. You have a significant history of failing to appear specifically in this court. On 24548, this court's going to order a $7,500 10% bond. Not be posted by not to possess, consuming alcohol or drugs unless prescribed and not to be released without an alcohol tether. As to 24546, the court's going to order a $7,500 10% bond. Not to be released without an alcohol tether, and this is through the Wayne County Jail. Not to possess, consuming alcohol or drugs unless prescribed. And as to 231957, the court's going to order a $5,000 10% bond. 23681A, $5,000 10% bond. We'll see you back on May 15th, sir.
Thank you.
I thank you. Have a good day. Abraham, City of Wine Numbers, Michael Abraham, 24544-201-534. And
Good afternoon, Your Honor. Neil DeBlois here on behalf of Michael Abraham, who appears via video conference from jail.
thank you. And Mr. Abraham, your name, please.
I'm Michael Scott Abraham.
Okay, are you not able to stand up, sir?
I thought you said sit down a second ago.
Oh, no, I didn't know if you had a medical reason you couldn't stand up. All right, and so today's date scheduled for arraignment is your client's in custody. There was a pending matter from 2020 that your client failed to appear on, and then a new matter And so council asks the arraignment.
As to the arraignment, my client waives the formal reading and stands mute to the charge. I have advised him of his constitutional rights in this matter. He has completed a advice of rights form, and I believe he understands those rights.
All right, and so the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule these matters for pre-trial May 15th at 10:15 a.m. And as to bond counsel.
As to bond, my client indicates that he resides with his parents there in, I believe that's Wyandotte, Bondi Street. Is that Wyandotte, sir?
Yes, sir.
He is a longtime employee of the Chuck D. Tree Service, 5 years or more. Beyond that, he admits there's at least one warrant out there, as you've just indicated, Judge, which he hopes to resolve as soon as possible. Ask the court to take those things into consideration when setting a bond.
All right, sir, where have you been other than here in court?
Just working. Is it really?
Well, sir, we've been trying to handle these matters with you and you continue to not come to court.
Sorry about that.
Sir, if you were to test today, anything in your system?
What's that?
If you were to test today, is there anything in your system?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay, and so what would that be?
Weed, alcohol.
All right, and do you have a prescription for marijuana, sir?
No, I don't.
And other than in this court, sir, have you ever failed to appear in court for any reason?
Yes, ma'am.
Okay, and so where's that?
Southgate, Green Park.
All right, and so have you resolved those matters or are there warrants for your arrest?
Warrant.
Okay. All right, well, to ensure Mr. Abraham is going to be appearing in these matters, as he has failed to appear on one matter in this court, and then he has other matters he's failed to appear on, the court's going to order a $5,000 10% bond on each matter. In the event you post bonds or you're not to be released on a GPS tether through the Wayne County Jail. I'm sorry, GPS and alcohol tether.
All right.
Not to possess or consume any alcohol or drugs that are not prescribed.
All right.
Anything else, counsel?
Nothing further, Your Honor.
All right, we'll see you back on May 15th. All right, thank you. All right, now, Ms. Perry, we're going to finally finish yours. All right, let's recall the matter of Aaron Perry, 24220.
Yes, Your Honor. Yeah, Neil LeBlanc here on behalf of Aaron Perry. Stands to my right.
All right, thank you. And Ms. Perry, your name, please.
Aaron Perry.
All right, is Travis Noble here? No, okay. All right, today's the date scheduled for sentencing in this matter. On your client's plea as charged with domestic violence, and counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we went through the report thoroughly. My client indicates that it is accurate with one addition. She has taken on additional employment since I think the report was compiled. Where is this new employment?
RP McMurphy's.
And it's at a part-time?
Full-time.
Full-time at RP McMurphy's. Add that to the factual basis of the sentence investigation report. With respect to recommendation, the recommendation seems to be appropriate for the most part. The client is very appreciative of being able to have advantage of the deferral under 769.4A. Would like to address the 0.5 in the recommendation, the outpatient substance abuse counseling. The court would consider not imposing that particular portion of it. The client advises, and I've looked at the reports and so forth. She has no criminal history whatsoever. She has a clean driving record. In this particular matter, this was one of these relationship things. This relationship is over. and we're good. Is that correct?
That's correct.
This former gentleman has vacated the premises, and she's no longer in a relationship with that person. There, in this particular case, she's not proud of the situation, and she's taking responsibility for her actions on that day. There was, does not appear in any way involve alcohol or drugs. Is that true?
That's correct.
And so, an outpatient substance abuse counseling program doesn't seem to be appropriate, to my mind. Beyond that, we'd ask the court to adopt these recommendations.
Okay, well, there are a few things that this court has some concerns with. Number one is that there were two weapons involved, and quite frankly, ma'am, you really could have been charged, and maybe more appropriately, should have been charged with a felony. There was a knife that was alleged in this incident, as well as a cooking pan that Mr. Noble was hit on the head with a number of times. And so I have some serious concerns with that. I also have some concerns with perhaps if there was some sort of substance use that's occurring. And so the recommendation for outpatient substance use would be appropriate. And ma'am, I do have a question as well. So you say that you're employed part-time and you earn $150 a week.
Yes.
Okay. Why are you only working part-time?
That was until I could get the other job that I have now.
Okay, what's the name of that job again?
It's at our.
Okay. And are you still receiving the $700 per month on the Bridge card?
Yes.
And how often do you work at our?
5 days a week.
Okay. So here's where the court's going to.
I'm sorry, before you,
Oh.
I might interrupt you. She advised me that I don't think that's shown up before. You are starting counseling, or have started counseling?
It starts on Wednesday. I had to wait for a date to come.
And that's through the guidance center.
Yeah, for sure.
Okay, is that outpatient substance use counseling? What type of counseling is it? Yeah.
It's for therapy.
Okay. Well, that would satisfy I have a note on here for mental health counseling, so that would satisfy that. But there is absolutely going to be substance use counseling. The court's going to state the following. After hearing from counsel, hearing from Ms. Perry, reviewing the report, the recommendation, the police report, the lack of criminal history, the court's going to find that there is reasonable grounds to affirm MCL 769.5. The court's going to order 12 months probation. You're not eligible for early discharge. You are eligible under 769.48. You're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're notified probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is for the court to monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so that you may maintain sobriety and prevent relapse. You are to attend the family meetings once per month. The rehabilitative goal for that condition is to give you additional support for maintaining sobriety and to offer you additional recovery resources. You are to participate in mental health counseling. So you're starting that already this week. So just get that information over to probation, okay? The rehabilitative goal for that condition is to allow you an opportunity to identify your mental health needs and to work on appropriately processing those needs. The court's going to order no assaultive, abusive, intimidating, harassing contact with Travis Noble. But the two of you are no longer in a relationship?
That's correct.
You don't have any children in common?
No.
And you don't live together anymore?
That's correct.
Okay, so the court's going to amend that to be no contact. No phone contact, text message, email, social media, third party, anything of the like. Not to possess any weapons or firearms. Do you have any in your possession?
No.
Any in your home at all? Okay. You are to participate in domestic violence counseling, 26 weeks domestic violence counseling. The rehabilitative goal for that condition is to assist you in expressing your feelings and needs in appropriate fashion when you're in an upsetting situation. The court's going to order $0 in restitution. None has been requested yet. And I have a condition on here for you to seek and maintain full-time employment, but you have full-time employment now, so I'm not going to proceed with that or the applications. Ma'am, it's very fortunate that you didn't have more serious charges and that there weren't any more serious injuries. I'm hoping all of these conditions, ma'am, will assist you so that this matter doesn't repeat itself. As to the fines and costs, the court's going to order a $500 fine, $100 screening assessment fee, supervision oversight fee of $600. That's 12 months at $50 a month. Since you're not eligible for early discharge, all of that money will be due. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. So $1,625. Do you have any of that to pay today, ma'am?
So Your Honor, I don't.
Okay. How much will you be able to pay per month and what day of the month works best?
100 a month, in the middle.
Okay, so can you begin that next Friday, May 17th?
Yes.
Okay, so $100 per month beginning May 17th, the 17th of every month thereafter. All right, ma'am. I certainly hope that this is a one-off for you and that there are no other issues moving forward. Please have a seat in probation. Somebody will be with you shortly.
Okay.
All right, this is the matter of the city of Riverview versus Dean Howard-Randolph, 24196. Good afternoon.
Good afternoon, Your Honor. Attorney Gaten Robinson, P71733, on behalf of Mr. Howard-Randolph. Mr. Howard-Randolph, can you take the name of the record?
Should be Howard-Randolph.
All right, and good afternoon. I do apologize for your wait. And so today is the date scheduled for the adjourned pretrial. There have been a couple of pretrial dates, and then Ms. Gaten Robinson had been appointed, and then on April 8th,
I appeared, I think it was April 8th.
yes, you had appeared via Zoom, and so then we set this for a jury trial for May 31st with a final pretrial for today, May 6th. And then counsel, there's been a resolution to this matter, is that correct?
Yes, Your Honor, I don't know if the court will allow me to approach with brother counsel or not. I don't know what the court's policy is.
Okay. Okay.
I'm not sure where brother counsel is. He's not in his room. His coat and his laptop are still there, but he's not there. So I don't know if he went to the restroom or what. It was just with regards to the no objections to credit for time served. As the court is well aware, this case is linked to another case that was just recently resolved in front of the court where he possibly did more than 45 days of jail. And then he's also being monitored with some domestic violence batterers training courses that he's been ordered to take by the court. I was just going to ask the court to take that into consideration with their sentencing, consider giving him credit for time served, and brother counsel had no objection.
Okay, so you're asking for immediate sentencing?
Yes, if possible.
Okay. I believe Mr. Howard-Randolph had recently been sentenced, I think, within the last couple of weeks, right? Okay. I don't recall all of the terms and conditions at that point.
He has a batterers counseling class that he has to take for 26 weeks. He starts that on Wednesday. He's already paid the fee to begin that. And he's checking in with the probation department via the phone on Wednesdays, what you said? The 13th, on the 13th, was the first time to check in with the probation department.
Okay, right, on Zoom, right? Just call?
Zoom.
Zoom.
Yeah.
You were given a meeting ID?
Yeah, I have a meeting ID.
Yes. Okay.
Sure.
Yes, okay. Okay, so, I can't say exactly what I'm going to do right this second, but it would probably not serve much purpose for Mr. Howard-Randolph to be on probation simultaneously on a different case like this when he was just sentenced. So, and the court is very familiar with the history of Mr. Howard-Randolph. And so, counsel, do you want to proceed with the plea?
Yes, Your Honor. And just for the record, this case is linked to that case. So this case happened at the police department where he went to the police department to pick up some of his property from, that was in the possession of the police department from that case.
Correct.
So it's all a bundle.
Yes.
Essentially. So yes, Your
Yes.
Honor, we are prepared to proceed.
Okay, please raise your right hand, sir. Do you solemnly swear or from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, and just please remove your hands from your pockets. And you heard the plea that your attorney placed on the, oh no, we didn't place this here. We're gonna put the plea on the record. I think we just said there was a resolution. Can you please
Yes.
place the plea on the record?
Your Honor, there is an offer for him to plead to disturbing the peace with a no objection to credit for time served, as he just recently did time in the Wayne County Jail. And so that is what I have discussed with Mr. Howard, and he has indicated to me that he's interested in accepting that. Is that correct?
Yes.
All right, and so Mr. Howard-Randolph, you did hear the plea that your attorney just placed on the record, correct?
Yes.
As to the amended charge of, I show disorderly conduct. Is that correct?
That's fine.
Okay, as the amended charge of disorderly conduct, how do you plead? Any immigration issues?
No, ma'am.
All right, counsel, if you can please body your claim.
Your Honor, may I have the date?
February 26th,
On February 26th, were you in the city of Wyandotte?
sorry, Riverview.
Riverview, were you in the city of Riverview?
Yes.
At some point in time, did you go to the police department?
Yes.
And when you went to the police department, were you given some instructions by the officer?
Yes.
Did you follow all of the instructions that you were given by the officer?
No.
Did you ultimately end up being arrested by the officers?
Yes.
And when you were arrested by the officers, did you refuse to do some of the things they instructed you to do?
Yes.
Was your conduct disorderly when you refused to follow the instructions of the officers? I'm satisfied now.
Court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. And counsel, you're asking for immediate sentencing?
Yes, Your Honor.
Okay. And is there anything you'd like the court to know in addition to what I already know? Or is there some significant change in the last couple of weeks? Or what would you like me to know?
Your Honor, there hasn't been a significant change in the last couple of weeks, other than the fact that he's finally back to work and he's trying to maintain his employment. He, after having been incarcerated more than a month and a half, it threw everything off in his life. And so he's now trying to build back up his life. And so he's just asking the court to take that into consideration. He understands the instructions of the court that he got from his last case. He is actively participating in doing that. Just in a short time, he's already paid the fee. He's already set up his meeting, and he's already prepared to start that on Wednesday. And so we just ask that the court takes that into consideration and run this case concurrent with the other case so that he's not paying multiple fines and costs, reporting 2 different times, missing work, having to give more excuses to his job. If we could just get it so that he's doing it once at one time, and since it's all through the same court, we greatly appreciate it.
Okay, and let me just clarify that Mr. Howard-Randolph, the time that he was incarcerated was because that was the sentencing that this court had imposed for violating his bond conditions regarding no contact after a bond violation hearing, even with the complaining with the victim in the other matter that had that you had referenced, counsel.
Okay.
So that was the reason for the 45-day jail. It wasn't because he was in there on a bond on this matter specifically.
Your Honor, Mr. Randolph has indicated that he doesn't want to be sentenced today now. I'm not sure why, but.
What was that?
Fears of the court. Stuff like that.
Okay, let me just tell you that you're not gonna have to get your affairs in order. I'm not sending you back to jail right now. Here's what I am inclined to do. The court, I'm going to order, I'm going to order 90 days jail. I'm going to suspend 45, give you credit for 45. Okay, with the jail review. So if you go back to jail, it's it's on you, right?
Yes.
Okay, as long as you're complying with all your terms and conditions of probation on the other matter, then you should be good to go. Okay,
Thank you, Your Honor.
all right. So that's the sentence of the court.
Thank you, Your Honor.
You are welcome.
All right, have a great day.
All right, thank you, you as well. On the record, in the matter of the city of Wyandotte versus James Eister, 24549. And appearance, counsel?
This is James Eister right here.
Good morning,
Okay,
Your Honor.
Okay, sir.
Appearing on behalf of my client, this time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
Okay, and I'm sorry, counsel, can you repeat your name again for the record? There was, Mr. Eister was talking while you were, talking.
Yes, Christopher Shepke, appearing on behalf of my client, P74025.
Okay, thank you. All right, and Mr. Eister, your name again, please?
James Philip Eister, 92761.
Okay, the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment, schedule this matter for pretrial on May 22nd at 9:45 a.m. And counsel asked to bond.
Your Honor, as to bond, my client indicates that he does have an opportunity to stay at certain shelters. Couldn't give me a specific address, although he indicates he will appear at any all future court dates, so we'd respectfully request leniency when determining the appropriate bond. Thank you, Judge.
And so, Mr. Eister, I believe you were recently here, were you not?
No, this was before, Halloween in October. And I served 92 days for a disturbance to the community of alcohol intoxicated.
That's right, because you were originally charged with indecent exposure, and then you, it was amended to something different.
Okay,
So let me,
I had served the 92 days and it was January 31st when they let me out.
okay. And so, and now, sir, you stay in shelters?
I'm on my way.
You're on the way where?
To Lincoln Park.
Here's what the court's going to do. Based upon the allegations in the report, based on a prior issue that you were given a warning and a ride home, or ride somewhere, given the close proximity as to train traffic and other concerns, and the fact that you don't have a home, that an address that you can provide to the court's going to order a $10,000, 10% bond in this matter. In the event you do post a bond, sir, GPS alcohol tether to the Wayne County Jail, not to possess or consume any alcohol or drugs that are not prescribed. And we'll see you back on May 22nd.
Thank you, Judge.
Anything else?
No, Your Honor.
All right, thank you. Have a good day. Let's go. First, Michael Phillips, 231705B.
Good morning, Your Honor. Christopher Shepke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Okay, and Mr. Phillips, your name for the record, please.
Mike Phillips, Your Honor.
All right, today's date scheduled for a probation violation. Mr. Phillips is currently on probation for disorderly conduct, and it's alleged that he failed to appear for drug tests March 20th, April 3rd, April 10th, April 5th, April 12th, April 11th. He also tested positive for marijuana and also failed to appear for probation on April 11th. And counsel?
Yes, Your Honor. As to the violations, these are technical violations. I don't believe that we're going to be requesting a hearing to suggest that they're not accurate. My client will admit responsibility, but we'd like an opportunity to allocate. Thank you, Judge.
All right, and so please raise your right hand. You solemnly swear or affirm the testimony you have to give this matter to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, and sir, you heard the plea that your attorney stated on the record, correct?
Yes, Your Honor.
And as to those allegations, sir, how do you plead?
Guilty, Your Honor.
And you understand these would be technical violations 1 through 6?
Yes, Your Honor. However, I would like to provide an explanation.
Okay, we'll get to that. And you also understand, sir, that you do have the right to have a hearing in this matter. By entering into a plea, you will not have that hearing.
Yes, Your Honor.
All right, and you also have gone over your advice of rights for probation violation purposes, correct?
Yes, Your Honor.
And you understand the possible penalty as a result of your plea. And you understand the recommendation here is for you to have your probation continued and serve 5 days jail, pay $50 probation violation fee. Do you understand that?
Yes, Your Honor.
And knowing all that, you want to still continue with your plea?
Yes, Your Honor.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please run to your client.
Yes, I'd like to take your attention back to March 19th, 2024. Did you fail to make a drug test on that date and time?
I do not believe so. To my knowledge, I have missed 1 or 2, but the other violations,
Are you indicating that you made a drug test? You went and tested on March 19th?
Yes.
Right. Setting that aside, would you admit that you failed to test as ordered on April 3rd?
I do not believe so, because I was calling, well, not my probation officer, but whoever works with her, because she was out at the time, and she said that I could test a day or 2 after because of my work schedule at the time.
Did you test on April 3rd, yes or no?
No, it would be the day or the day after that I tested.
The subsequent day after, 2 days after, on April 5th, will you stipulate that it indicated the use of marijuana in your system?
Yes.
Did you fail to make a drug test on April 10th, but then later, 2 days later, go to a drug test?
Yes.
And then will your April 12th, did you indicate that there was use of marijuana?
Correct, yes.
And did you fail to report to probation on April 11th?
Yes.
Satisfied, Your Honor?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement and, or per the plea. And as to the recommendation, counsel.
Your Honor, as the recommendation, I'd ask that any jail time be put in suspended status. I'd give my client an opportunity for a jail review and see if he can complete probationary terms with no further sidesteps or other incidences which would cause for a violation. Thank you, Judge.
Okay, so, all right. So, sir, I hear what you're saying regarding you couldn't go one day, you're told to go another day. I do show March 19th that you didn't show up, and then you went on March 22nd. So that's not one that you were violated for. Oh no, March 20th you were violated for because you went 2 days later, not the next day. On April 4th, you didn't show up because you were, so as you just testified, April 3rd, you couldn't go, you were told to go the next day. You still didn't go the next day. Then you went April 5th and you're positive for marijuana.
Correct.
Okay. Well, sir, then April 11th, you didn't go, or you didn't go April 10th. So then you went, then you were told to go April 11th. You didn't go that day either. You went the 12th and you were still positive for marijuana. And in fact, you were higher than you were, well, no pun intended, your levels were higher than you were on April 5th.
Correct, Your Honor.
So, okay, and then you didn't even appear for your probation appointment April 11th. At that point, your probation officer was back. And the court will note, yes, sir, your probation officer was out unexpectedly. So why didn't you show up for your drug testing those days, sir?
Yeah, I'm sorry, Your Honor. I've been working 6 days a week, so I really haven't been able to. That's the reason, and the whole first quarter that I was going to drug test a couple days late, and there was 2 instances where I was not able to make it just due to work. I had just started this.
Hold on, sir, I'm sorry.
Nope,
Where is
nope.
it you're working?
Excuse me, Your Honor.
Where do you work?
Foundation Systems in Michigan.
Okay. And how long have you been working there?
About 7 months, 6 months maybe.
Okay, what is your work schedule?
I work Monday through Friday, and then Saturday, they'll ask me to work. It's here and there, but lately it's been Saturdays too. So it's 7 a.m. to around 7 a.m. to whenever the job gets done, which usually ends up being around 7 p.m.
Okay. And what time does DNA open, sir? Or are you testing it on-site or DNA?
On site, and yeah, they open at 7.
They open at 7.
Yeah, and they close at
Yes.
6:30. Yeah, correct.
Yes?
Yes.
Okay. And so at any point, sir, did you contact anybody in probation
No, I did not.
to ask for an alternative based upon the time? Because I thought that they opened up at 5 or 6 a.m. or 6 a.m.
Not to my knowledge, no, or else I would have just went before work.
Right. And then you were testing, and then when you were testing, you were testing positive for marijuana.
That's correct. Yes. Well, I was taking gummies at first, which aren't supposed to have no THC in it, and I had a medical card, but it expired. I wasn't under the impression that gummies you can get from like any store would show up for marijuana, but I'm understanding that now.
Well, sir, I'm not even sure. I mean, you were ordered no alcohol or drugs unless prescribed. And so we had 6 violations here. Why didn't you appear for your probation appointment on April 11th, sir?
That was my fault. I thought it was the day after. I've just had a lot going on with work, and my daughter just started soccer, so I've been had a lot on my plate lately, and that's the reason for most of this. But I definitely should have the 2 times that I actually missed and didn't call in. I should have had that written down and remembered. It's my fault.
Here's what the court's going to do. The court's going to order you to continue to comply on terms of probation. The court's going to order 5 days jail. I'm going to suspend that jail, sir. 1 more violation, you're serving that time and more time, sir.
Okay. Thank you, Your Honor.
And let me be very clear. Let me be very, very, very clear, sir. You are not to use any substances. If you think that something does or does not have a substance in it, it's your responsibility to know what the ingredients are.
Yes, Your Honor. I understand.
Your lack of appropriate planning, sir, quite frankly, given what you have to do, it's not working for you.
Yes, Your Honor, I understand. I'll change it.
So what's your plan moving forward to make your drug tests?
I will have to be a lot more organized and make sure I have alarms set and a calendar, everything that I need. So there's no way I could possibly miss one. And if I have to take a day off work or risk my job to make it, I will. So.
Sir, why don't you do this, right? Why don't you talk to your probation officer about another location to test, one that opens sooner? How about that?
All the on-site ones are pretty far from me except for the Lincoln Park one, but they don't open when I need them to. So,
okay. And so you live in your other option, sir, is Your other option is DNA, which is in Woodhaven. That's an option.
Is that on site, Your Honor?
No, sir, I just said that's DNA. That's the name of the company.
Okay. Okay, I'll have to talk to
So-
my probation officer about that.
Talk to your probation officer so you can see, jams may be an option. There are other options, but you need to communicate that with your attorney.
I understand, Your Honor. I apologize.
All right, email into Ms. Shaw by 11:15, sir, of Jan Michael Wagner, 232334B. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
All right, and so Mr. Wagner, you are currently on probation. You were sentenced on March 20th, and it's alleged that you tested positive for cocaine and alcohol on April 5th, and you failed to appear for your drug test April 15th, and you're currently on probation for possession of narcotics. And counsel?
Yes, Your Honor. I've gone over my client's right to have a hearing in which he can contest these violations. That will not be necessary.
Sir, please raise your right hand. Do you solemnly swear or affirm, Mr. Wagner?
Yes, ma'am.
Please raise your right hand. Do you
Hello.
solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you've heard the plea that your attorney stated for the record, correct?
Yes, ma'am.
And as to the allegations, sir, how do you plead? Guilty or not guilty?
Guilty. Ma'am,
And you've
nice
gone
to
over
meet
your advice of right. You've gone over your advice of rights with your attorney, correct?
Yes,
For
ma'am.
probation violation purposes, and you understand all of those rights.
Yes, ma'am.
You also understand by entering into a plea, you'll be waiving some of those rights, specifically your right to a contested hearing.
I understand, ma'am.
And you understand the possible penalty as a result of your plea in this matter. Specifically, the recommendation for you to have your under advisement status revoked, continue and complete all terms of probation, $50 probation violation fee, 30 days on the alcohol tether to be served after you serve 10 days jail. Do you understand that?
Oh, I do understand, ma'am.
No, I'm sorry. There's a recommendation that the jail be suspended. Do you understand that?
Yes, ma'am.
And knowing all that, you want to continue with your plea.
Yes, ma'am.
Has anybody promised or anything, threatened you or coerced you in any way for you to enter into a plea?
No, ma'am.
All right, counsel, you can please pardon your client.
Yes, although you said that you don't recall missing a test on April 15, 2024, will you stipulate that a drug test taken on April 5th indicated the use of cocaine and alcohol?
Yes.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. Technical violations 1 and 2 will enter. And counsel, as to the recommendation.
Your Honor, I do appreciate that the recommendation is for suspended jail time. I would respectfully request consideration for the deferred sentence not to be revoked at this point. Obviously, there'll be the scenario where he has a 30-day alcohol tether, and it really is his to lose. So I would ask that that be adopted, but potentially there be consideration for the 7411 or whatever pertinent statute he availed himself of to remain intact, absent any further violations. Thank you, Judge.
Okay. Well, let's see here. So, Mr. Wagner, you were charged, you pled to possession of narcotics on January 9th. You were scheduled for sentencing February 7th. You failed to appear for that. Then we did sentence you. I'm sorry, what?
I was in the hospital that day. Sorry.
Judge, or excuse me, Mr. Wagner, I'd advise not to interrupt the judge any further. She'll have an opportunity to speak.
So you were ultimately sentenced on March 20th. And 2 weeks, 2 weeks, 2 weeks later, sir, you're testing positive for cocaine. And then a week after that, you failed to show up for your testing. If you were to test right now, sir, what's in your system?
I should be clean.
And if something were to be detected in there, what would be detected?
Nothing. I haven't even been taking my clopidogrel. Nothing.
Well, when you say you should be clean, why would you not be clean?
Because I screwed up a little while back, but I've been staying home and being clean.
Okay, when you say a little while back, when is that?
Maybe a week.
Okay. So when's the last
But it
time you
wasn't
tested,
much.
sir?
And I chased my friend off. I said, don't come back.
Which friend was that?
Excuse me?
Which friend was that?
They're no longer my friend, ma'am.
And when was the last time you tested?
A week ago?
So did you
Thursday?
use
Thursday
after
was a
you,
week?
okay, did you use after your last test, or did you use before your last test?
I think it was right after.
Okay.
Ma'am, may I say something?
Yes.
I am truly sorry. I don't want to go to jail. I will stay in the house here for as long as I need to. I'm just asking for mercy from the court, and I promise it'll never happen again.
Well, sir, here's what I'm going to do, right? Because staying in the house isn't necessarily going to be helpful, because somebody could come over and bring you whatever you're asking for. So, have you cleared up your warrants, sir, that this court ordered you to start doing?
Not yet, ma'am. I just got back to work. I was put out from Malice, and I just got back to work, self-employment, doing brickwork. I'm supposed to be there right now. I just by chance found out about court by calling my probation officer.
Okay. So did you attend the fan meeting in April?
No, I didn't, and I called my probation officer to let her know all of my paperwork was missing out of the van. Somebody broke the window, stole my folder. That's no excuse. I know this. None of it is an excuse.
Okay, listen, what I'm hearing are a lot of reasons why you're not doing things that you're supposed to be doing.
I understand, ma'am.
You have a smartphone, is that correct?
Yes, ma'am.
Good, then take pictures of any paperwork you get so you have it in case it's lost. Put the dates for the fan meetings in your calendar.
Okay. Understood.
What this court's going to do is this court's going to, well, sir, did you let your probation officer know about your change in employment status?
Not yet. I just got her on the phone. She said I was supposed to be at work, or supposed to be at court.
Did you have an appointment with your probation officer today?
That's what I was trying to see if it was this week or next week. Like I said, my folder is not there anymore.
Well, you can always go online, sir, on the court website, and you can look up your name, and then it should be able to tell you all of your next dates.
I appreciate that. I did not know that.
The court's going to adopt the recommendation. The court's going to order you to continue and complete all terms of probation. The court's going to revoke your under advisement status. The court's going to order you to pay a $50 probation violation fee. I'm going to order 10 days jail. I'm going to suspend that jail. Sir, if you end up in jail, that's on you. That's on you. Because that tells me that you violated again.
Understood,
If you don't
ma'am.
want to go to jail, start complying with all of your terms and conditions of probation.
Yes, ma'am.
30 days on the alcohol tether. So when we're done here, you're going to email back into Ms. Shaw so you can get the information regarding the tether. You also, sir, need to start attending your fan meetings. If you miss one, that's a violation, sir.
Understood.
Any questions?
Where are the fan meetings held at? Should I just go back into the court and get more paperwork from my probation officer so I know all of this?
Oh, that may be helpful, or you can see if she can email it to you, but the Lincoln Park chapter meets right there at the Turning Point Clubhouse. It's the third Thursday of every month at 6 o'clock. I'm sure you're given all that information, even verbally,
I was.
by a probation officer.
Yes, ma'am.
Any other questions?
No, Your Honor.
No, ma'am.
All right. Email into Ms. Shaw right now.
Thank you, Judge.
Okay. All right, thank you. We're going to be off the record.
Thank you, Your Honor.
You're welcome. Have a good day, sir.
You too. Sir?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
It's a joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.